Hi, everyone, and welcome to Educate, Inform, and Challenge. My name is Teresa MacLennan, and I'm the Executive Director of the Women and Children's Shelter of Barrie. We're very happy that you've joined us today. The goal of our show is to talk about the lives of women, the experiences of women, and to really challenge our thinking about some of the things that we think we know. We're going to be talking about issues of violence against women, women in leadership, and talking about gender equity. So we're really glad that you're with us today. And so before we begin, we always want to acknowledge and thank our Indigenous people for allowing us this space to share this land, to share this opportunity with you. We thank them so much. And I am thrilled today to welcome my guest, Jo-Anne Kyte. And Jo-Anne, welcome. And would you like to introduce yourself to our viewers?
Hi, thank you for having me. I'm Jo-Anne. I'm the Family Court Support Worker at the Women and Children's Shelter.
Jo-Anne, how long have you been in that role?
It'll be 5 years this year. 5 years in the role as the Family Court Support.
Wonderful. And so, you know, we have had other conversations with other folks about violence against women, and we want to dive into the experience that women have going through the court process. So let's start at the beginning. What would be the circumstances that women would need to or choose to go to court?
There's a varied need to go to court. Sometimes when there's charges against their partner and the conditions dictate that there must be a family court order in order for parenting time and child support to be arranged, then a woman must go to court to get that court order in play in order for there to be a parenting time regime set. There's other times where mediation and separation agreements wouldn't necessarily work because of the power imbalance in the relationship. So having the courts to help you process and move things along is a better way to get to where you need to be. So custody being the biggest issue, which is parenting time, and then decision-making on the children, and of course, child support for the woman and the children.
So can you differentiate for our listeners the difference between family court and, let's say, criminal court?
The family court only deals with issues around the children and the distribution of your marital assets or your relationship assets, because you don't necessarily have to be married to have family court. Criminal court deals with the charges that one person might experience because they violated the law.
Okay, so I think that that's helpful because I think that just, you know, in my relationship and knowing you, that sometimes you will also get asked as a family court support worker to become involved in criminal cases. And just clarify for us, that isn't the role that you take.
It's not the role. First of all, there is an agency in place to help women navigate the criminal process. So when partner's been charged, and she needs to attend court or she needs to know what his conditions are, Victim Witness Assistance Program is the program that would help her through that process, help her do a statement, an impact statement when needed. So there's that program is already in place. Family court is navigating all of the other components around the children and your home.
Thank you for that clarification. I think that that is really important for our viewers, our listeners to know. So I really want to start to dive into the experience of women who are going through that court process. And, you know, I'm really looking forward to hearing you speaking and advocating for women who go through that process and really what that looks like for them. So what would you say are the most challenging pieces for women who've experienced violence who are now needing to go to court?
There's the most challenging, I think, would be the fact that the abuse continues throughout the court process. Many judges and lawyers think that they're no longer with the partner, therefore abuse doesn't exist. But we watch the legal bullying that happens through the whole process, where partners, ex-partners are refusing to participate in the process. They're hiring and firing lawyers. They're not providing documentation. They're not following orders. And so it puts the woman at a disadvantage because she's constantly having to fight to get something done. Only the courts keep giving chances to the other side, specifically when he doesn't have a lawyer, and most men will self-represent in order to push the process into a longer piece for them. Then there's there's things like COVID. COVID has created a challenge. You have to have internet, you have to have technology, you have to have knowledge of the use of it in order to be attending court. The plus is that you don't have to see your abuser at court, because that was one of the other pieces, is being safe at the courthouse. Is he's there with his family, he's there with his new partner, and you're in close proximity. So there's the fear of harm, there's the fear of him saying something. So we're constantly having to make sure that there's a security officer around, or the duty counsel knows, or the court services officers are aware that this is an abuse, this is a domestic violence case, and so we need to make sure that there's protection in place.
So I think this is really a great conversation, and I think I want to just sort of pivot a little bit and ask you a question and get your opinion on this. But when women are going through that court process and they're, at the beginning, standing before the judge, their abuser may be in the room, like you say, extended family, his new partner, her new partner, whatever that looks like. Are women needing to prove that they have been abused? And how difficult is that during that process?
So up until March the 1st of this year, when the laws changed, that was definitely a difficult process, because it didn't have a lot of weight. The abuse was looked at as a way to determine whether or not they qualified for spousal support. It didn't dictate what was in the best interest of the children, what was happening in the home to the woman, and why having to do a shared parenting regime was a difficult process. March the 1st, the courts, the Divorce Act and the Child Law Reform Act both changed. And what they did was they incorporated a definition of abuse. And so now the judges need to look at that definition when making decisions, as well as offering perspectives to the parties on what would be in the best interest of the child. So now they have to look at what was the exposure to the children of the abuse in the home, and how would that challenge a shared parenting regime or a shared decision-making regime.
And so how responsive, you mentioned changes to the Divorce Act, how responsive have you found from your own experience and what women have shared with you, are the justice of the peace, are the judges to those changes, and are they helpful?
So there has been a positive movement towards looking at the inability for the parties to do a shared parenting or a shared decision-making. And so looking at splitting the decision-making. So one party might have sole decision-making in, say, education or in medical, where the other party might have sole decision-making in school. And then when the children are with either parent, during that time that they're with the parent would be responsible for making the day-to-day. So you're not having to kind of check in, hey, I want to take the child to the beach today. And I mean, but the idea is I want to go to Niagara Falls. You would have to check in, you'd have to get permission. Now, with a day-to-day, you're able to you have more autonomy in your decision. So there is some positive movement. However, at the other side of that, when you talk about the justice of the peace, when we're looking at, peace bonds for women, and they're identifying that there's domestic violence, that they're not meeting the test of the severity in order to get a peace order.
So I think that that's something that I'd like to circle back to and just talk about that process in terms of peace bonds and what that looks like. And, I think that some of the experiences that you certainly shared with me in the past has been And you use the word legal bullying. And I think that that is just a really important place for us to maybe end off this conversation before we head into a break. Can you give us just a couple of examples again of what that legal bullying looks like, which really indicates that the abuse is continuing, even though that man and that woman may be separated?
So holding off on trying to come up with minutes of settlement where they have an agreement. So demanding that they have a higher say in what's happening. Hiring and firing of lawyers, not providing documentation, self-representing, even self-representing themselves at trial, which puts them in a position of questioning the person they abused through the trial because they don't have a lawyer to do that. So those are the kinds of things that continue to happen in the courts, and asking the judges for leniency. Look, Your Honor, I don't know what I'm doing. I don't have a lawyer. Meanwhile, she's provided everything that needs to happen, and they're waiting on financial statements, and they're in order to determine child support or determine spousal support, or refusing to sell the house, holding up the sale of the house. That can go on for months and months and months. That puts everybody in a position of, well, she's in a state of homelessness and she's having to pay rent when there's equity in the home that she could use to help build a better home for herself and the kids, and she can't access it because he's holding up the sale of the home.
So Joanne, just a really quick question before we head into our break. How long can that court process actually go on for?
So ideally, it would be nice if you could get it all done in a year. I have women that are back and forth. It's been 10 years that they're back and forth in this process. 2-3 years is a pretty good number to try to get it sorted out. It really depends on whether or not the judges are pushing the parties towards an agreement or getting to a trial. And of course, with COVID now, everything has been pushed even more.
Okay, we're going to circle back and we're going to dive in even deeper to this conversation, because it is really so crucial for any woman who's listening to us today to have an understanding of the court process as much as they can in our half an hour discussion. So stay with us, and we will come back to the conversation with Jo-Anne. We look forward to seeing you soon. Welcome back to Educate, Inform, and Challenge. And again, my name is Teresa MacLennan, Executive Director of the Women and Children's Shelter of Barrie. And today we've been talking with Jo-Anne Kyte, who is the family court support worker. And Joanne supports women through that court process once they have left their abusive partner. And so we're going to pick up in our conversation and dive in deep to talk about how that process looks for women. We talked about some of the legal bullying, the tactics that can take place that really prolong the process. And Joanne was talking to us that, that process could take, 3, 5, in really awful situations, up to 10 years in terms of those court cases to be settled. One of the things that we want to talk about now, so that we as a community, as viewers, we fully understand, is restraining orders, because it does come into play when we're talking about, of course, mothers and fathers and abuse. And so, Joanne, help us to understand, what is a restraining order and what does that look like?
So a restraining order is something that someone would secure if they need to have their ex-partner not be near them at all. So a restraining order would look like where there would be conditions where he wouldn't be allowed within a certain parameter. Sometimes it's 100 meters, 500 meters, can't attend the home, can't attend where she works, can't attend the school, or anywhere she ought known to be. So if she's at the shopping mall and he happens to be in the same shopping mall and he sees her, he must leave. That is how it's supposed to work. Oftentimes with a restraining order, though, it's a piece of paper and it doesn't really hold a lot of weight But if a woman carries it on her and calls the police, then they can then execute charges against him for a breach of his conditions. Restraining orders you could get through the criminal law court. So if he's been charged with assault or domestic violence or mischief against her, he would have a restraining order through criminal court. When he pleads his case and and a decision's made on his charges, that restraining order drops. So a lot of times what will happen is we try to get a restraining order through family court because that stays in for a little bit longer while we try to navigate how to be safe. What are some of the things that she needs to do to be safe? Restraining orders don't last forever.
Okay, and do restraining orders, if she has a restraining order, does the restraining order also include any children, or is it only for the woman?
So it depends on what happened. So if he was charged with an assault against her and the children were witnessed, there may be a restraining order that includes her and the children. Or there was an incident where the children were involved in the assault, there would be a restraining order that would prevent him from contacting the children. Most times, if it's just an assault against her, then the restraining order only is for her. He does have access to the children, but he has to be able to communicate with her in order to be able to get access to the children, which is why they have usually it's a variation on the conditions that says through a third party or through a family court order made after this date. So no contact whatsoever, direct or indirect, no phone calls, no internet, no Facebook, no mother calling or brother calling or friend calling her, no contact, except for those specific things.
So, of course, we are a women's shelter, so we support women who have had an experience of abuse. And as our listeners have heard me say before, of course, we know that men are abused as well. They do experience violence, but the rates of women experiencing violence and domestic violence in particular is much, much greater than men. So in our conversation today, we are talking specifically about women. So I just want to clarify that for our viewers. But I want to ask you this question, Joanne, and it's a big one, but if a woman has been abused by her partner and then there are children involved, if she is concerned about abuse to the children, she is concerned about when the children go to him that he's going to use his abuse in a different way, in saying bad things about her to the children. Does that happen? And what recourse is there? Like, how do parents figure that out?
So absolutely concern for the children, specifically when the children have witnessed incidences in the home, name calling, yelling, even pushing, or more violent attacks. The children have been exposed, they've witnessed. And so mom definitely has concerns about the children being around dad when dad has displayed these behaviors in front of the children, regardless of the fact that they were there. So when moms bring that up to the courts and asking for things like supervised access, which gives dad time with the children, but it's under a supervision so that if he starts to escalate or he uses drugs or he's drinking or, his anger is out of control or he can't self-regulate, that there's someone else there to take the children to safety. A lot of times what happens when you're asking for supervised access, when you're asking for there to be some kind of a monitoring happening when dad is with the children, dads come back with, that's parental alienation. She's alienating the kids from me. She's making me look bad, right? And so when they bring that to court, it opens up a can of worms in the courthouse because now the judges have to look at, is mom being reasonable in her concerns given her circumstance? And of course, like I said earlier, with March 1st being the changes in the laws, now we can look at, hey, this is her story, this is her history. There's been coercive control, there's been violence in the home, children have witnessed, there's been incidences where he might have been aggressive with the family pet. All of these things are now defined in the new acts to help judges make decisions or support women in looking at the safety of the children and how to keep them safe, and getting dad some support around parenting skills, because 10 to 1 he hasn't done a lot of parenting, or hasn't done as much parenting in the home that mom has, right?
So does that process actually work, or is it getting better? But does that process work, and is it favorable to the safety and minimizing risk for the children who are involved?
So March was the change, and things are fairly new. I have seen some cases coming out where the judges are starting to really, in making their endorsements, in offering advice, because during family court, there's two ways a judge will participate. One is to give their perspective, and the other is to make a decision. So when judges are offering their advice and perspective and offering or putting an endorsement together to make a decision, they are looking at the definition of abuse, and what the woman has disclosed is what happened in their home. So if the children have had exposure to an amount of violence, the judges are now looking at, yes, maybe supervision is the way to go, or we're not taking away parenting time from dads. We're not that, like, there has always been a 50-50 split. Parents are equal parenting time, maximum contact, but we're now looking at how that contact's going to look at. What are some of the things that we can put in place to protect the children when they're with dad, specifically if there's other issues that dad has, such as not being able to self-regulate and the use of substances.
So would the courts ever mandate or say that, let's say the parents or in this situation, the abuser would need to be involved with the Children's Aid Society if there's a risk to the child? Like, does that happen through the court process ever?
Not typically through the court process. I've seen a few matters where the judge has asked, where does the society stand on this issue? Has the society been brought in? Whenever there's an assault in a home, the society is automatically called. The police have to involve the society. So they have to do an investigation. A lot of times the society will look at, well, the children are with mom, they're not with dad, mom and dad are not together. Therefore, there's no more adult conflict happening in the home. So they may not keep the case open or the file open because the children are safe. However, they have said that if dad has unsupervised access, or there is a shared parenting regime that the courts are looking at, we will need to be notified because we may have some concerns.
And I think that that's great information and helpful for all of our viewers to know, is that certainly you and I, as service providers in our agency, all of our employees, and really anyone out in the city of Barrie, we have a duty to report to the Children's Aid Society, which is now called Family Connections, that if we have any concerns of a suspected risk of or abuse of a child, that we have a duty to report as service providers. And certainly we always encourage anyone in our community that if you are suspecting any risk to children, to make that call. And it isn't for us to make the decision whether or not abuse has happened to a child. That is the role of the Children's Aid Society to do that. So, Joanne, I think that there's so much that we could talk about, and it is such a big conversation to have. I want to wrap up our time today, just really giving you an opportunity to speak to women who are listening today, who may be with their abuser, who may be thinking about leaving their abuser, or maybe are starting that court process. What advice would you give to those women about how to navigate through that process?
I would say, first of all, it's always really important to get informed. So as a family court support worker, I can provide clients with a 2-hour domestic violence certificate that allows them to speak with a lawyer free of charge to them for up to 2 hours to get to know what their rights, what their responsibilities are, what are the next steps, so they have an idea before they walk out the door what to expect. And then, of course, calling the local shelter, doing safety planning always, because navigating the issues in the home can be difficult, and having a support system helps you make decisions and not feel stuck and isolated. So reaching out for support is one of the biggest things that you can do, is just to have someone to talk to. Talk to a friend. If you can't call the shelter, talk to somebody, let somebody know what's happening in your home, so that when you call them and say, hey, I need help, they know what to do and how they can move you into a safer place.
So certainly
having a plan.
Yes. So certainly we will share our crisis line number with any woman who is listening today. And Joanne, how can now, and we also want to clarify that you provide support to men who've experienced abuse as well as women. So
yes, I do. As a family court support worker, yes.
I mean, of course, the majority of the cases that you support are women. So in saying that, if there is a woman or a man who is listening today and they would like to get in touch with you just to talk about your support, talk about their options, what's the best way for them to reach you?
They can reach me through my email or my work cell. Those are the two main components. Working remotely because of COVID has certainly changed how people connect. So my email is jo-anne@barrieshelter.com.
Great.
And then my work cell is 705-790-5353.
Terrific. And if anyone's listening and they're not, they're not sure where to start, our crisis line is probably a great place to start. And that number again is 705-728-2544. And that crisis line is 24 hours a day, 7 days a week. And so, Joanne, I want to thank you so much for sharing with us your role, this wonderful support that you provide to, the women in our community, and just how necessary it is. I cannot imagine for women how difficult the process is trying to navigate the paperwork and being prepared for what it is that they need to do when they go through court. So thank you so much for being with us today, Joanne. And we want to thank our viewers.
Thank you.
Hope that this has been an insightful, educational, and inspiring conversation. And we look forward to seeing you again next time. Thank you so much for joining us, and take care.